No, of course I was.
I can even oppose the road.
How are you? It's been a while by now.
Yeah. We have to know. Yeah. It's really. No, we think it's
No, of course I was.
I can even oppose the road.
How are you? It's been a while by now.
Yeah. We have to know. Yeah. It's really.
We're going to stretch us.
Yes.
Yes. Let me first check you.
It's okay. Thank you.
Thank you, Lord. Is that enough?
It's enough.
Yeah, they would have received those guys. They wouldn't have allowed me even to reach here.
Doctor.
What's the appearance like this morning in this matter?
This is your worship. My name is Ernest Kalibala. The team that is representing the applicants is led by Landfill Elias Wabo and Samuel Muizi Indwa, Aaron Kizza,
Mawe? Cyrus?
Mr. Second Abubeka, Mr. Chifu Michael, Mr. Bayan Nawe,
Richard. Well, the ruling is ready, and I have instruction to pronounce the same. Mr. Application number 113 of 2025, arising from Nakawa capital case number 8 of 2025 at Nakawa Chief Magistrate Court. Colonel, retired Dr. Kizza Besigye. 2, Abed Lutale versus Uganda. Before Honorable Lady Justice Rosette Comfort Kania, ruling. The ruling is of 17 pages. Lead counsel, you want each and every word written on this ruling, or you want salient features? And for the one who has not yet, who did not get the chance of getting to UPE, yet is interested, we shall pronounce the whole of it, I think, for the benefit of the public. Background. Colonel retired Dr. Kizza Besigye and Abed Lutale, hereinafter referred to as the first applicant and second applicant, and where the context permits, the applicants were charged with 1, Section 223, Subsection 1, Part C of the Penal Code Act, Cap 128. 2, misprision of treason, contrary to Section 25 of the Penal Code Act, Cap 128. The prosecution alleges that the applicants and others still at large between the year 2003 and November 2024, while in various cities, including Geneva, Switzerland, Athens, Greece, Nairobi, Kenya, and Kampala, Uganda, contrived a plot, act, or matter by force of arms to overturn the government of Uganda, as by law established and expressed or declared such plot, act, or matter by utterances and overt acts. In the alternative, the prosecution alleged that the applicants and others still at large in the places and in the time frame aforementioned, knowing that another person intended to commit treason, did not report the same to the authorities or use all reasonable endeavors to prevent the commission of treason. Legal basis of this application. The applicant brought this application by notice of motion under Article 23, Clause 6 of the Constitution of the Republic of Uganda, 1995, Section 15 and 16 of the Trial on Indictments Act, Cap 25, and Rule 2 of the Judicature Criminal Procedure Applications Rules, for orders that A, the applicant be admitted to bail and released from remand / custody. The grounds of this application are stated in the application and further detailed in the affidavit in support deposed by the applicants are briefly that A, on the 21st day of February 2025, the applicants were charged with treason and misprision of treason at the Chief Magistrate Court of Nakawa at Nakawa and remanded in custody. B, the offenses with which the applicants are charged are only bailable by this honorable court. C, the applicants are responsible citizens of Uganda who have permanent places of abode as follows. First applicant at Buyinja LC1, Wampe Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, South Division, Rukonjiri Municipality in Rukonjiri District. Second applicant at Kisigula Village Cell, Mutundwe Ward, Gombolola Sabagabo, Makinde Wakiso District for the second applicant. D, the applicants are not a threat to any investigative or other processes and are willing to appear before this honorable court for mention or trial as and when once released on bail. E, the antecedents of the applicants demonstrate this respect for the law and for any bail processes they have benefited from. The applicants have not been committed to High Court for trial and are willing to comply with all reasonable conditions set for their admittance to bail. J, the applicants are of advanced age and have substantial sureties who are willing to ensure compliance with bail conditions once applicants are released on bail. H, it is fair and just that the applicants be admitted to bail and released accordingly. At the hearing, the applicants were jointly represented by Honorable Elias Lukwago, Mr. Ernest Kalibala, Mr. Apollo Katumba, Mr. Wanda Samuel, Mr. Samuel Moyezi, Mr. Kunhira Proskovia, MS, beg your pardon, MS Kunhira Proskovia, Mr. Kato, Mr. Bayan Turinawe, Mr. Farouk Kamlegaya, Mr. Kintu Michael, Mr. Amanya Timothy, Mr. Kato Wilson, and MS Silas Oguru. The respondent was represented by Chief State Attorney Joseph Chomuhendo and Chief State Attorney Richard Birivumbuka. Both the applicants and respondents made oral submissions at the hearing and filed written submissions for which this court is grateful. The said submissions have been considered where necessary. Submissions. It was submitted for the first and second applicants as follows. Article 23, 6A of the Constitution of the Republic of Uganda as amended spells out the right of an accused person to apply for bail and enables this court to grant bail on such conditions as it considers reasonable. Section 15 of the TIA, Cap 25, provides that this honorable court may at any stage of the proceedings release the accused person on bail. Pursuant to Section 16, subsection 1 and Section 16, subsection 2 of the TIA, court may grant bail if an accused person is able to prove exceptional circumstances and that they will not abscond from the trial once released on bail. Counsel cited the case of Attorney General versus Joseph Tumushabe, Constitutional Appeal number 3 of 2005, Supreme Court, where it was held that it is no longer necessary for the applicant to prove exceptional circumstances before they can be granted bail. Counsel further cited the case of Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006, where court observed that the provisions of Section 15 of the TIA were only regulatory and did not take away the discretion of the court to grant bail in deserving circumstances. Once the exceptional circumstances are listed in law is one of the exceptional circumstances listed in law is advanced age. As it is provided under Section 16, subsection 3A of the TIA, and that guideline number 4 of the bail guidelines interprets advanced age as the age of 60 years and above. Counsel further submitted that the applicants are 68 and 65 years old respectively, and that owing to the advanced age of the applicants, they are not able to manage the harsh conditions in prison. Counsel for the applicants added that the applicants have been in custody since 16th November 2024, a period exceeding 120 days without being committed for trial. Citing the case of Tracy J. Charles versus Uganda, criminal application number 8 of 2011, counsel stated that the courts have recognized that prison conditions are not favorable to the health of old people who are in any case presumed to be innocent until proven guilty. Section 16, subsection 4 of the TIA and guideline number 13 of the bail guidelines provides for that other factors that the court might take into account in making the decision to grant bail is whether the applicant will abscond when released on bail. In support of the fact that the applicants will not abscond, counsel for the applicants says that although the applicants have been charged with serious, grave offenses which carry the death penalty, should the applicants be convicted, the gravity of the offense does not bar this court from exercising its discretion in favor of the applicants. It was further argued for the applicants that the law has allowed applications to be made even where individuals are charged with serious, grave offenses. Counsel added that in many decisions of the High Court, bail has been granted to applicants charged with grave offenses, including treason, terrorism, aggravated robbery, murder. That in the case of the first applicant, he has been charged with various grave offenses before and released on bail, and he has not been convicted of any of those offenses. In the case of Makoha Samuel and 35 others versus Uganda, criminal application number 24 of 2024, the International Crimes Division of the High Court, ICD, had the occasion to consider the question of gravity of the offense vis-a-vis a bail application, and held that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. The ICD also held that the fundamental principle for a court to release an applicant on bail is the presumption of innocence, and courts should favor the liberty of the accused, provided that doing so does not compromise the interests of justice. It was further submitted for the applicants that the nature of the offenses with which the applicants are charged are political offenses, and that these two are not. And on that account alone, the kind of offenses in respect of which bail cannot be granted, that the first applicant particularly has been charged with various political offenses over the years, offenses in respect of which no conviction has been returned by the respondent. Counsel cited Makoha Samuel and 35 others versus Uganda, Supra. Counsel submitted that other conditions to be proved before court include antecedents of the applicant, possibility of a substantial delay in the trial, the likelihood of the applicant to attend court, the stage of the proceedings, the likelihood of committing an offense while on bail, the likelihood of the applicant interfering with the witnesses. Counsel for the applicant cited the case of Panju versus R 1973 South African Law Reports at page 282, where the court held that allegations of interference with witnesses must be substantiated, and that such substantiation is not difficult to show. Counsel for the applicants concluded by stating that the other factors to consider in applications for bail are whether the applicants have fixed places of abode, have sureties, substantial sureties, and whether there are no other charges pending against the applicants. In reply, counsel for the respondent submitted as follows. Section 15 of the TIA and Guideline 3 of the bail provides conditions that court should take into account in considering bail applications, including the substantiality of sureties, nature of the offenses, age of the applicant, possibility of interference with investigations and witnesses, possibility of absconding bail, whether the applicants have a fixed place of abode, applicants' antecedents, and sensitivity of the charges. Guideline 15 of the bail guidelines offers guidance on what to consider while determining the suitability of the sureties, the age, work, residence of the sureties, character and antecedents of the surety, relationship of the surety to the accused, stroke applicant, and other factors as the court may deem fit. Regarding sureties, the first applicant produced 4 sureties, to wit, Honorable Semuju Nganda, a close friend, age 52 years. Honorable Francis Mujuche, a close friend, aged 41 years. Honorable Muhindo Harold Tony, a close friend, aged 52 years. And Honorable Nicholas Thaddeus Kamara, a close friend, aged 50 years. And that the second applicant, produced by Najita Halima, the second applicant produced Najita Halima Lutale, a wife and aged 58 years. Namfuka Zuhura, a daughter aged 27 years. And Counsel Sewa Kambo Hamza, a friend aged 48 years. Counsel submitted that all these sureties presented by both applicants are much younger than the applicants, and this makes the applicants superior to their sureties, and yet it should be the other way around. And in such a scenario, the sureties are unable to compel and influence the applicants to appear in court in the event that they abscond. Counsel cited the case of Mugera John versus Uganda, criminal administrative application number 21 of 2025 at International Crimes Division. Honorable Lady Justice Alice Komuhanyi Kawuka held, it is my considered view that a surety should possess a certain amount of authority and or influence over the applicant. The sureties presented by the first applicant have no authority and or influence over the applicants, and it will be hard for them to compel the applicants to comply with bail terms and are therefore not substantial. It was further submitted that the bail guidelines require that the letter of introduction from LOC1 should state to the court that the surety or applicant is not just a resident but a permanent one in that area. Whether or not the surety has a fixed place of abode is an issue that should be expressly stated in the letter of introduction and not merely implied. Additionally, counsel submitted that the relationship between the sureties and the applicant is paramount and has such bearing on the surety's ability to influence and compel an applicant to attend court when required. The first applicant produced only friends as sureties who don't provide sufficient assurance that the applicant will comply with bail conditions. Counsel add that friends do not have the necessary leverage or influence to ensure the first applicant's compliance and are most likely unwilling to take steps to enforce compliance. Counsel cited the case of Tusime David versus Uganda Criminal Administrative Application number 29 of 2019, where Honorable Justice Musa Sekana held that he was uncomfortable with cousins, even if they had fixed places of abode. Counsel stated that if court was uncomfortable with raising the applicant basing on cousins, then what about the instant case where the applicant presented mere friends? It would be more risky to release the first applicant with just friends as sureties. In his submissions, counsel submitted that the sureties have to prove and assure court that they will deploy their time and resources to monitor, influence, and compel the applicant to appear in court whenever required, and that none of the sureties for the applicants dispense this requirement. Counsel cited the case of Mugera John versus Uganda, Missions Application Number 2 of 2022, where Honorable Lady Justice Elizabeth Jane Alivisa upheld the above view. It was further submitted that none of the sureties provide their work or business identity cards. What was annexed are passports and national IDs, which have no relationship with the business or employment or gainful income and disposable income, which are critical in assessing their substantiality. In Asimu Anna versus Uganda, Criminal Minister Application Number 81 of 2024, court held that a job identity card alone is not sufficient to demonstrate the capacity of a surety to meet the terms of the bond. Therefore, failure to demonstrate financial capability of by the sureties, regardless of their position in society or government, is fatal and goes to the core in the grant of bail applications. Advanced age of the applicants is not the only ground or consideration for bail under Section 15 of the TIA, under which this application was brought. This court has to balance the interests involved, as was held in the case of Tumusime David versus Uganda, Criminal Missions Application Number 29 of 2019. The offenses with which the applicants are charged with are serious, grave, of public interest, impact on national security, and the applicants will abscond bail. In DPP versus Kano, retired Dr. Kizza Besigye, Constitutional Reference Number 20 of 2005, the Justice of the Constitutional Court held, among other things, that where there is a substantial likelihood of the applicant failing to surrender or turn up for trial, bail may not be granted for less. Bail may only be granted for less serious offenses. The court must weigh the gravity of the offense and all other factors of the case against the likelihood of the applicant absconding. In the case of Foundation for Human Rights Initiative versus Attorney General, Supreme Court Constitutional Appeal Number 3 of 2009, the Justice of the Supreme Court held, among other things, that this article imposes on court the duty to ensure that they do not only consider the rights of the accused person applying for bail, rather the court should the interests of society at large. The first applicant has another pending charge pending against him at Buganda Road Chief Magistrate Court, which is part hard. Section 15, subsection 4 of the TIA provides other pending charges as a consideration court should take into consideration in deciding whether or not to grant bail in an application of this nature. In the case of Honorable Alan Sewanyana Aloysius and Honorable Segirinya Mohammed versus Uganda, Masaka Criminal Application Number 18 of 2021, Justice Lawrence Tweyanze, while dismissing the application for bail, held that in an early application granted the applicant's bail, Lady Justice Victoria Nakintu, based on the fact that they had no other charges pending against them, but at the time of determining the present application, they have charges of murder against them, in addition to those they were earlier charged with. It was therefore submitted for the applicants, for the respondent, that the pending charges against the first applicant are a good ground to dismiss his application since he committed the current offenses while on bail via Buganda Road criminal case number 624 of 2023. In respect to the fixed place of abode, it was submitted for the first and second applicants that whereas the respondent contends that both applicants do not have fixed places of abode because they did not provide land titles or tenants agreements to show the fixed places of abode, and therefore they may not be located or held accountable if they jumped bail. Counsel for the applicant submitted that both the first and second applicants provided evidence on oath by way of 2 affidavits and attached LC1 letters in support by each applicant about their respective fixed places of abode. In the case of the first applicant, he provided 2 locations at Buyinja LC1, Wampeo, Ward, Kasanga Town Council, Wakiso District, and Rwakabengo A, Rwakabengo Ward, Southern Division, Rukonjiri Municipality in Rukonjiri District. And in the case of the second applicant, the location is Kisigula Village, Sel, Mutundwe Ward, Gombola Savagabo, Makindye Wakiso District, also within the jurisdiction of this honorable. Regarding pending charges, counsel for the applicant submitted that the second applicant has no pending charges against him, and that the first applicant having a pending charge at Buganda Road Court cannot be used to dismiss the second applicant's application as submitted by the respondent. Counsel further stated that the respondent has not provided any evidence of the stage at which the case at Buganda Road is, or whether in fact the first applicant has been put on his defense or found guilty. That he does not cease to enjoy the constitutional presumption of innocence because he has a pending case. Counsel for the applicant stated that the fact that the first applicant was charged with current offense while on bail in respect of the Buganda Road case cannot be used against him, as it is the same state that charged him that is now using those charges to argue that he should not be granted bail, alleging he reoffended while on bail. Regarding the possibility of interfering with the witnesses and the investigations, counsel for the applicants submitted that in Panju versus Ara, 1973, Volume 1, East African Road Reports at page 282, tell that the allegation of interference with the witness must be substantiated and that such substantiation is not difficult to show. Counsel submitted that there is no evidence that there has been placed before this court by the respondent to show that the alleged strong likelihood of interference with the witnesses or investigations. Counsel prayed that this honorable court finds no likelihood of interference with the unknown witnesses or investigations and dismisses the argument of the respondent. While submitting in respect of applicant's age, counsel submitted that the courts can, and in this case, should, take judicial notice that prisons are not holiday destinations. That the fact that there are harsh conditions on remand has been taken note of, including in cases cited by the respondent, such as the case, Okello-Augustine case. In respect of possibility of absconding, it was submitted for the first applicant and second applicant that since the arguments of the respondent seem to focus more on the first applicant, then the argument should not prejudice the second applicant, and that the evidence of the first applicant's mastery of the game, presumably referring to fleeing from Uganda, is not supported by any evidence. Counsel further submitted that the first applicant has demonstrated that in the past, when released on bail, and he required to travel outside the jurisdiction, he only undertook it with permission of the court. he would go out of the country and return. Regarding the sureties, it was urged for the applicants that the sureties presented were advised about their role of by the Honorable Court, and none of them protested or said that they were unable to perform their roles. In Kawanguzi Nsereko David versus Uganda, criminal miscellaneous application number 426 of 2023, the court held as follows. It is my considered view that the role of a surety goes beyond the ability to forfeit the bond. Bail is not designed as an income-generating avenue for courts to which bail applications are made. What is pertinent about sureties is that there must be indication that they have been advised of their roles as sureties. They identify themselves properly and have shown and proved their authoritative relationship in respect to which the applicant showing that they are able to exercise their authority and command appearance of the applicant in court when needed. As for the applicant, informed court that the sureties had been informed of their duties in respect of bail, which duties they understood well and committed to executing. Counsel further submitted that a proposed surety is required to provide A, a copy of his or her national identity card, and B, an introduction letter from the local council one chairperson of the area where the surety is ordinarily resident, as provided under bail guidelines. Counsel further submitted that the ages of the sureties, which ranges from 27 to 58, demonstrate adult persons capable of understanding what they are undertaking, and that none is a minor and none is a person of extreme old age. Therefore, all sureties have provided these documents. Citing the case of Chigongo Farouk versus Uganda, criminal application number 7 of 2024, cited with approval in Makoha case, where the Honorable Court stated that I firmly believe that this court is, in making its decision, must be cognizant of the socio-economic environment in which justice is dispensed, particularly the informal nature of the employment of the majority of Ugandans, that makes it difficult to possess documentary evidence of capacity to meet monetary obligations. To insist on documentary proof of capacity to meet monetary obligations in the event that the surety is called upon to forfeit the bond is to exclude swathes of the population of Uganda from the opportunity to stand surety for relatives and friends. This would tantamount to discrimination against a section of the society on the basis of their socio-economic class. The courts have long held the view that if courts are to simply act on allegations, fears, or suspicions, then the sky is the limit, and one can envisage no occasion when bail would be granted whenever such allegations are made. Counsel for the applicant submitted that the respondent provided no evidence to rebut the grounds relied on by the applicant in support of their applications. It was prayed for the applicants that this Honorable Court finds that the applicants have each satisfied the requirements in the law and on the applicable facts to enable this Honorable Court to exercise its discretion in their favor and release them from custody on bail on reasonable terms. Determination. 1. Law and the evidence. Article 23, 6A of the Constitution provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Although the Constitution guarantees an accused person the right to apply for bail, the court at all times retains the discretion whether or not to grant an accused person bail. See Foundation for Human Rights Initiative versus Attorney General, Constitutional Petition number 20 of 2006. The primary principle for which a court may release an accused person on bail pending trial is the presumption of innocence. This legal principle is enshrined in Article 28, Subarticle 3 of the Constitution, which provides that every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Section 15(1) of the TIA, in addition to upholding the right of accused person to apply for bail, clothes this court with the discretion to release an accused person on bail at any stage of the proceedings. Guideline 5 of the bail guidelines provides the general principles which a court may take into account while considering a bail application. The principles include the presumption of innocence, the right to liberty, applicant's obligation to attend the court, discretion of the court to grant bail on such terms as the court considers reasonable, and the need to balance the rights of the applicant and the interests of justice. Having examined the applicable law on bail, I will now turn to the merits of the application. Right to apply for bail and the court's discretion to grant bail has already been addressed as above, and it is clear that the applicant has a right to apply to court to be released on bail, with the court having the discretion whether or not to grant bail under Article 23(6) of the Constitution. Presumption of innocence. The principle of presumption of innocence is a constitutional one, and as noted above, the bail guidelines require this court to consider the principle of presumption of innocence and personal liberty in determining bail applications. In relation to personal liberty, the active principle in granting bail is that of upholding the liberty of the individual while simultaneously protecting the administration of justice. See Abed and another versus Uganda, application number 20 of 2016. The presumption of innocence means that an accused person should not be taken in custody and deprived of his freedom unreasonably. Bail should not be refused merely as a punishment, as this would conflict with presumption of innocence. Fixed place of abode and substantiality of sureties. A fixed place of abode. A fixed place of abode for an applicant must be within the jurisdiction of this honorable court, as it guarantees the court that the applicant stroke accused person cannot be found can be found in the event of absconding. To underscore the importance of the provisions of proof of a fixed place of abode, it can be a ground for refusal to grant bail. It is therefore imperative for the court to be persuaded that the accused person has a fixed place of abode, because it is a pointer to the fact as to whether the applicant is likely to abscond once granted bail. Section 16, subsection 4 of the TIA is instructive in this respect, as it provides in considering whether or not the accused is likely to abscond. The court may take into account the following factors: A, whether the accused person has a fixed place of abode within the jurisdiction of the court, or is ordinary resident outside Uganda. The point made in section 16, subsection 4, part A of the TIA is amplified by paragraph 13K of the bail guidelines, While the law does not define the phrase fixed place of abode, what is important is that fixed place of abode must be within the jurisdiction of the court, considering the bail application. Where the applicant fails to prove this under Section 16, Subsection 1 of the TIA, then the court may deny him bail. In the case of Foundation for Human Rights Initiative versus Attorney General Constitutional Petition number 20 of 2006, it was held that the nature of the offense and sentence of the applicants and whether the applicants have a fixed place of abode in the court's this jurisdiction should be strongly considered by the court in an application for bail. Remy Kasule J. Inamugenyi Stephen versus Uganda, business application number 65 of 2004, held that the onus is on the applicant to satisfy the court that he has a permanent place of abode in a particular village, sub-county, and district. This is to enable the court to exercise its discretion, to exercise its jurisdiction over the applicant, while on bail being able to trace his whereabouts whenever it is necessary. In respect of this application, the applicant states that, that under paragraph 3 of the notice of motion and paragraph 1 of the first applicant's affidavit in support of the application, that he has a fixed place of abode within this court at Buyinja LC1, Wampeo Ward, Kasanga Town Council, Wakiso District. And Rwakabengo A, Rwakabengo Ward, Southern Division, Rukonjiri Municipality in Rukonjiri District, within the jurisdiction of this court. The applicant submitted a copy of his national identity card, the original of which he submitted for court inspection, and an introduction letter endorsed by the chairperson of Buyinja LC1, Wampeo Ward, indicating that he is a resident in his area of jurisdiction. The second applicant says that he has a fixed place of abode within the jurisdiction of this honorable court at Kisigula Village, Sel Mutundwe Ward, Gombolola Sabagabo, Makinde Wakiso District, within the jurisdiction of this honorable court. The applicant submitted a copy of his national identity card and an introduction letter endorsed by the LC1 chairperson of Kisigula Village, Cell B, indicating that he is a resident of his area of jurisdiction. Paragraph 12A of the bail guidelines provides that an application for bail shall contain particulars of the applicant, accompanied by a copy of the national identity card and an introduction letter from the chairperson LC1 of the area where the applicant resides. The village, parish, and district, as stated in the introduction letter, are well known and are within the jurisdiction of this honorable court. Excuse me. By furnishing court with a copy of the national identity card and an introduction letter from the chairperson LC1, the applicant has satisfied the onus placed on him to prove he has a permanent place of abode. C. Kayongo Bashir versus Uganda, criminal application number 158 of 2019. Therefore, the applicants have satisfied the requirements to prove a fixed place of abode. B. Substantial sureties. The term surety is defined by paragraph 4 of the Constitution, bail guidelines for courts of judicature, practice, directions, legal notes number 8 of 2022. To mean a person that the applicant will appear in court and abide by the bail conditions and who furnishes security which may be forfeited to the state if the applicant fails to appear in court. Therein lies the main duty of a surety. What is pertinent about sureties is that there must be indication that they have been advised of their roles as sureties. They identified themselves properly and have shown and proved their authoritative relationship in respect to the applicant, showing that they are able to exercise their authority and command appearance of the applicant in court when needed. Section 16, subsection 4, Part B of the TIA and paragraph 13, 1 of the Constitution, guidelines for courts of judicature, practice directions, provides that in considering whether an actual person is likely to abscond, the court shall consider whether the accused has sound sureties within the jurisdiction to undertake that the accused shall comply with conditions for his or her bail. Guideline 15 of the bail guidelines sets out 1. Factors that the court shall take into account in determining the suitability of a surety: age, work, and residence address, character and antecedents, relationship with the applicant, and any other factor court may deem fit. 2. Documentation in respect of a surety that must accompany an application for bail include a copy of the national identity card, passport of alien identification card, introduction letter from the LC1 chairperson of the area where the surety is ordinarily resident. The applicants in the affidavits in support of the application aver that they have sound and substantial sureties who have fixed places of abode within the jurisdiction of this honorable court, and in the event that they are granted bail, they undertake to ensure their compliance with all the terms set by this honorable court in the event that the applicants are granted bail. The first applicant presented 4 sureties as follows. 1. Honorable Semujunga Ibrahim, a 52-year-old male, member of Parliament of Kira Municipality, a resident of Boyogere Division, Kira Municipality. Honorable Semuju is the first applicant's close friend. On file, an introduction letter from the chairperson LC1 of Castle Cell, Kirinya Ward, Boyogere Division, Kira Municipality, indicating that Honorable Semuju is a resident of his area of jurisdiction, and a photocopy of Honorable Semuju's national identity card. Honorable Semuju presented his original national identity card for court inspection. 2. Honorable Muhindo Harold Tone, a 52-year-old male adult, member of Parliament for Bukonzo County East, a resident of Katale Busaula, Chengera Town Council. Honorable Muhindo is the first applicant's close friend. On file, an introduction letter from the LC1 chairperson of Katale Busaula Cell, Chikajo Ward, Chengera Town Council, Wakiso District, indicating that Honorable Muhindo is a resident of his area of jurisdiction, and a photocopy of Honorable Muhindo's national identity card. Honorable Muhindo presented his national identity card for court inspection. Photocopies of the documents are on record. Honorable Francis Mujuche, a 41-year-old male adult, member of Parliament for Buhwejo District, a resident of Rutete Kelezia Cell, Masoli Ward, Kasanga Town Council. Honorable Mujuche is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Rutete Masoli Kelezia Cell, Masoli Ward, Kasanga Town Council, Wakiso District, indicating Honorable Mujuche is a resident of his area. And a photocopy of Honorable Mujuche's national identity card is on record. Honorable Mujuche presented the original of his national identity card for court inspection. For Honorable Kamara Nicholas Thaddeus, a 50-year-old male adult, the MP for Kabale Municipality, a resident of Buye, Chigowa LC1 Bukoto 2 Parish, Nakawa Division. Honorable Kamara is a close friend of the first applicant. On file is an introduction letter from the LC1 chairperson of Boye Kigowa 1 LC1 Bukoto, 2 Parish, Nakawa Division, Kampala, indicating that Honorable Kamara is a resident of his area and a photocopy of Honorable Kamara's national identity card is also on record. Honorable Kamara presented the original of his national identity card for court's inspection. That presented 3 sureties as follows. Najita Halima Lutale, a 58-year female resident of Kisugu, Makindi Wakiso district. She is the wife of the second applicant. She is a businesswoman engaging in business with her husband. She presented an introduction letter from the LC1 chairperson of Kisugula village cell, Mutunde Ward, Gombolola Sabagabo, Makindi Wakiso district, indicating that she is a resident of his area. Mrs. Lutale presented the original of her national identity card for court's inspection. 3. Siwankam Hamza, a 48-year-old male resident of Kanabe village, Ndege Parish, Sabagabo Makindye, Wakiso district. He's an advocate practicing with the Soankambo and company advocates. Mr. Soankambo is the brother of the second applicant. He presented an introduction letter from the LC1 chairperson of Kanaba cell, Ndeje Ward, Ndeje Division, Makindye Sabagabo Municipality, Wakiso district, indicating that he is a resident of his area. Mr. Sewankamo presented the original of his national identity card for court's inspection. 3. Namfuka Zura, a 27-year-old female, resident of Lukuli-Konge Parish, Tiaba Zone, Kampala District. She's a journalist by profession. M.S. Namfuka is the daughter of the second applicant. She presented an introduction letter from the LC1 chairperson of Tiaba Zone, LC1 Lukuli-Konge Parish, Makindye Division, Kampala District, indicating that she is a resident of his area. M.S. Namfuka presented the original of her national identity card for court's inspection. By presenting the originals of their national identity card, the letters of introduction from the chairperson LC1, where they ordinarily reside, the sureties satisfy the conditions set out in Guideline 15 of the bail guidelines. The aforementioned guidelines do not provide guidance on the format the introduction letter should take and what it must state. Neither do they make reference to permanency of residence in terms of owning property, as alluded to by the respondent by his reference to land titles and sale agreements. Persuaded by the respondent's argument that the first applicant's sureties are not suitable as sureties, owing to the fact that they are friends and not blood relatives, younger than the applicants, and therefore are not able to execute their duties as sureties. The first applicant's sureties are his close friends and leaders in a political party of which the first applicant is a member. By virtue of their position as close friends of the first applicant and leaders in a common political party, they are able to exert influence over the applicant to ensure that he abides by his bail terms in the event that he is released on bail. The fact that they are younger than the first applicant, notwithstanding, reference to age in the bail guidelines as a parameter for determining suitability of a surety does not indicate that a surety must be necessarily older than the applicant. It is enough that the surety is a responsible adult with a connection to the applicant, capable of exerting influence on the applicant to comply with his bail terms. In the premises, I find the first applicant's sureties substantial sureties capable of exercising authority over the first applicant to ensure that he abides by the conditions of bail in the event he is granted bail. The second applicant's relationship to his sureties as husband, father, and brother respectively. The fact of their being younger than the applicant notwithstanding, in my view, arguments their ability to compel him to comply with his bail conditions in the event that he is granted bail. It is enough that the sureties provided copies of their national identity cards and introduction letters from local council chairpersons of the areas where the sureties are ordinarily resident, as set out in paragraph 15 of the paragraph 15 2A and B of the Bail Constitution Guidelines for Courts of Judicature, Practice Directions 2022. The aforementioned guidelines do not provide guidance on the format of the introduction letter that should take and what it must state. Neither do they make reference to permanency of residence in terms of owning property, as alluded to by the respondent by his reference to land titles and sale agreements. Accordingly, the declared relationship between the sureties as close friends presented by the first applicant arguments their suitability as sureties. Also, the declared blood relationship between the second applicant and his second and third sureties, and the relationship of the first surety as the wife of the first applicant arguments their suitability as sureties. Although, as one of the factors to consider in determining the suitability of sureties, the bail guidelines mention age. It does not, in my view, indicate that the surety must always be older than the applicant. It is enough that the sureties are adults in positions of responsibility or so connected to the applicant that they are able to exert pressure on the applicant to comply with their bail conditions if granted bail. To say that a surety must always be older than the applicant is to set a dangerous precedent where senior citizens of very advanced age may never be able to find sureties who are older than them. I therefore find that the first and second applicants have satisfied the requirements to present substantial sureties. Exceptional circumstances. It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where there are no exceptional circumstances. Uganda vs. Retired Colonel Dr. Kizza Besigye, Supra. That proof of exceptional circumstances is an application. That proof of exceptional circumstances in an application for bail is not mandatory. In this application for bail, however, the first and second applicants rely on the advanced age as their exceptional circumstances. Section 16, subsection 3, Part C of the TIA provides that exceptional circumstances include the infancy or advanced age. There's no doubt that the applicants are 68 years, 65 years old, respectively, are of advanced age. The applicants have succeeded in proving exceptional circumstances in the context of Section 16, subsection 3, Part C of the TIA. In this case, the applicants have proved that they have a fixed place of abode, substantial sureties, are of advanced age. Both applicants have not been found guilty of any offense previously, while the first applicant has charges pending against him at Buganda Road Court. The second applicant has no other charges pending against him. The first applicant was released on bail in respect of the charges pending against him at Buganda Road. By interpretation of the other charges against the applicant does not extend to charges in respect of which the applicant was released on bail, and it has not been proved that before he had deliberately or for no justifiable reason failed to abide by bail terms. Gravity of the offense, nature of the offense, and possibility of trial. Counsel for the applicant cited the case of Makoha Samuel and 35 others versus Uganda, where the applicants were granted bail while being charged with terrorism, contrary to Section 6, subsection 1B and Section 2 and subsection 2, Part B of the Anti-Terrorism Act. It was submitted for the respondent that the applicants in this case of Makoha, Samuel, and 35 others versus Uganda Supra are charged with terrorism, which attracts life imprisonment on conviction, while the applicants in the present case are charged with treason, which attracts a sentence of death upon conviction. I am persuaded that on the scale of gravity, the charges against the applicants in this case attract the ultimate penalty and therefore are graver than the charges against the applicants in the case of Makoha Samuel and 35 others versus Uganda. While the charges in both cases are grave, the charges in the present case, in the present application, are more serious. Counsel for the applicants stated that the International Crimes Division of the High Court held in granting the applicants bail in the Makoha case said that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. In that case, the prosecution stated in their affidavit in opposition of the application that there was sufficient evidence against the applicants. In the present application, the respondent has stated that the investigations are still ongoing and has not made any assertions about sufficiency of the evidence against the applicants, basing on the evidence so far adduced. This court is therefore unable to make a determination on the sufficiency of evidence pointing to the guilt or innocence of the applicants. In the Uganda DPP versus Colonel retired Dr. Kizza Besigye, Constitutional Reference number 20 or 2005, it was stated that in relation to bail, the extent to which evidence is pointing to proof of guilt or innocence of the applicant would seem to be one of degree in circumstances of a particular case. Counsel for the applicant submitted that no evidence has been adduced in support of the averment that the offense impacts on the national security of Uganda. It was added that the investigators have placed nothing before this court to suggest that there is evidence of any nature at all to suggest that what they aver. In their response to this point, counsel for the response submitted that the charges with which the applicants are charged, treason, involves violent change of government. I am inclined to side with the respondent that treason being an offense that involves overthrowing government, which act is accompanied by violence, an act of treason impacts on national security of Uganda. Possibility of interference with investigation, and it was submitted for the applicant that there is no likelihood of the applicants interfering with the witnesses. Counsel for the applicant cited Panju versus Ara, 1973 South Law reports at page 282, where it was held that allegations of interference with the witnesses must be substantiated, that such substantiation is not difficult to show. In reply, counsel for the respondent submitted that The first applicant is a prominent and influential person, and the second applicant is his personal assistant, that in releasing them on bail, will accord them the opportunity to interfere with witnesses and investigations which are still ongoing. As for the respondent, on the case of Okello Augustine versus Uganda, application number 6 of 2012, where the court emphasized that once the likelihood of abscondment and interference with investigations have been established, the court should be hesitant to grant bail. In this case, the respondent states that the applicants are very influential people with the ability to interfere with investigations. Although the respondent has not gone ahead to state in detail how the applicants are likely to interfere with the investigations which are ongoing, the particular circumstances of the case against the applicants must be borne in mind. The offenses are said to have been committed in various jurisdictions, and the charges are extremely grave. I agree with the respondent that the applicants are very influential people with the wherewithal to interfere, with the likelihood to interfere with the investigations which are still ongoing. Decision. The main considerations for bail, for release of an accused person on bail are the right to liberty and presumption of innocence. Article 23 of the Constitution provides that no person shall be deprived of personal liberty except in execution of the sentence or order of a court, whether established for Uganda or another country, or of an international court or tribunal in respect of a criminal offense of which that person has been convicted, or of an order of court punishing the person for contempt of court. Article 28(3)(a) of the Constitution provides every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Article 23(6)(a) of the Constitution, in recognition of the fact that liberty may be curtailed even where a sentence or order of the court is pending, provides that where a person is arrested in respect of a criminal offense, the person is entitled to apply to the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Article 23(6) of the Constitution entitles accused person to apply to court to be released on bail. It is clear from Article 23(6)(a) of the Constitution that accused persons, in respect of the gravity of the offense, are entitled to apply to be released on bail. However, the discretion remains with the court to grant or reject the application for bail. See Uganda versus Colonel retired Dr. Kizza Besigye, Constitutional Reference number 20 of 2005. Among the considerations for exercise of this discretion is the gravity of the offense. Courts will more readily grant bail or for less serious offenses than the serious offenses. The offenses with which the applicants are charged are among the gravest, if not the gravest, offenses of our statute books. In all cases where applicants are charged with capital offenses, the court must always have in its mind the overarching consideration of the gravity of the accusation against the applicants and the sentence that it attracts. As stated in the case of Uganda, Supra, while acknowledging the release of one accused person on bail is premised on the right to liberty, there should be peace and safety of the people and their property. The court of law and all other organs of government have a duty to ensure that national and international security is preserved. Therefore, the fundamental rights of the individual must be balanced with this greater public interest. In this regard, court has to consider whether there is justification to interfere with the accused person's right to liberty pending his or her trial. The circumstances of the present case are that it is alleged that the offenses were committed by the accused persons in various jurisdictions, including Kenya, Greece, Belgium, and Netherlands, with other persons still at large. The investigation into the charges against the applicants have not been concluded. By the fact that the offenses are alleged to have been committed in various jurisdictions, investigations are unlikely to be wrapped up as speedily as investigations in respect of offenses alleged to be committed only in Uganda. It was urged for the applicants that their continued incarceration, while investigations which do not have a clear timeline of conclusion are ongoing, is prejudicial to them, as it is not clear when the investigations will conclude, to facilitate the committing of the applicants for trial to the High Court. Counsel for there will be, therefore, this substantial delay in commencing the trial. Article 23(6)(c) of the Constitution provides that where a person is arrested in respect of a criminal offense, tried only by the High Court, such a person shall be released on bail on such conditions as the court considers reasonable. If the person has been remanded in custody for 180 days before the case is committed to the High Court, I am of the opinion that this provision takes into account circumstances like the circumstances of this case, where one reason or another, investigation cannot be concluded speedily, and provides a cap on the time on remand, without committal beyond which time the accused person shall be mandatorily released on bail. To safeguard against the right of the accused person to liberty being indefinitely curtailed. Where the applicants for bail have not yet clocked mandatory bail, bail is a matter of court's discretion, as provided under Article 23(6)(a). In this case, the applicants have, among other factors, proved they have a fixed place of abode, have substantial securities, are of advanced age, and are of first-time offenders, since they have never been convicted of any criminal offense. It has also not been proved that on a previous occasion, when granted bail, the applicants did not abide by the bail conditions. While the first applicant has charges pending against him at Uganda Road Court, for which he was released on bail, the second applicant has no charges pending against him. As cited in John Muhanguzi Kashaka versus Uganda, Supreme Court Miscellaneous Application number 18 of 2023, all factors to a bail applicant's credit, including being a first offender, being advanced age, having a fixed place of abode, recede to the background when weighed against the seriousness of the offense. In John versus Uganda, Court of Appeal of Uganda, Miscellaneous Application number 99 of 2013, it was stated that the granting of bail by court one before court is essentially an act of the exercise by court of its discretionary powers. The court considers all that is before it regarding the application for bail, and reaches a decision based on the rules of reason, justice, and law. Therefore, although I find that the applicants have satisfied all the relevant requirements for grant of bail, such as proving that they have fixed places of abode, have substantial securities, are first offenders with no criminal record, and are of advanced age, the application for bail is denied for the following reasons. 1, the charges against the applicants are among the gravest, if not the gravest, on our statute books. The offenses are alleged to have been committed in various locations in Uganda and in other countries, requiring more time and resources to conclude investigations than is normally the case in offences alleged to have been committed only in Uganda. Owing to the fact that the investigations are ongoing, the interests of justice at this point indicate that the application for bail is denied on this occasion because there is a likelihood that the applicants, if released on bail while investigations are ongoing, owing to the grave nature of the offense, may fall prey to the temptation to interfere with the investigations. Signed, Rosette Comfort Kania, Judge, 11th April 2025. We shall overcome. We shall overcome someday. Give my heart, I do believe. We shall overcome someday.
Kano Dr. Kizza Besigye bwatyo wamiddwa bail ng'omulamuzi agambye wajja kutaataaganya okunoonyereza n'olw'ensonga eyo bail temuweereddwa yennaku eriwo gemaziga agaliwo buli omu yeebuuza ate nga buli omu adde agamba nti waaye ekigambo kitambudde bulungi naye abiganye.